There we go. Okay, good afternoon, everybody. Today is Thursday, August the 8th. My name is Judge Esparza. We have some writ hearings scheduled for this afternoon. The first case we're going to call is C 3584-24-E, State of Texas versus Ana Trevino.
Good afternoon, Your Honor. Cynthia Cantu del Bosque on behalf of Ms. Trevino.
Good afternoon, Cynthia. Ms. Trevino is present in the courtroom with her attorney, who will be doing the interpreting for her, correct?
Yes,
Okay,
I'll let her know what happens is
okay.
or
Who's here for the state? Veronica?
Yes, Your Honor. Good afternoon. Veronica Bernal, present on behalf of the state.
Good afternoon. You may proceed, Mr. Bosque.
yes, Your Honor, Ms. Ana Trevino is a U.S. citizen and she does reside in Alamo, Texas. She resides alone, Your Honor, and she is also deaf. She's here on a PLCS. It's a state jail felony. The bond is at $20,000 cash assurity. At this time, she does not have the resources to pay that bond. Additionally, I just found out on the way over here that she also has a case pending in County Court 1 for assault, Judge, that she did not receive notice. I noticed that the arraignment notice had been returned. I've already scheduled that to be set for Tuesday, Judge, and so we'll address that case there. But for here, in this case, I'm asking that the court grant her a APR bond, Judge.
Okay, what does the state?
Your Honor, the state's position is no reduction. My notes indicate from Ms. Leon Vargas that the defendant currently has an active NISI on the assault in CR 2209-847-A. I understand counsel's position. I'm not aware about the proper notice or not, but as of this time, we're at a no reduction.
You have her contact information, Mr. Bosque?
Yes, I'll get it from her before I leave, Judge, to make sure it's the same.
Yeah, I noticed she's been in custody 33 days. I'm gonna go ahead and reduce the bond to a $2,000 PR bond. I'm gonna order monthly UAs. Make sure she understands no drugs, no alcohol during the time this case is pending.
Yes, Judge.
She does have a NISI in CR 2209-847-A. You may want to contact the court about getting appointed on that case. I think Mr. Randy Lopez was on it, but he filed a motion to withdraw just last week, I think, or a month ago.
Yes, Your Honor, the second. I'll go ahead and make sure to get that case taken care of, situated.
Bond will be reduced to $2,000 PR with monthly UAs.
Thank you, Your Honor.
Your Honor, if I may,
I'm sorry, Veronica?
I apologize. I would just like to add no harmful contact with the victim, Gloria Linda Cavazos, in that case.
On the assault case?
Correct.
Judge Arnold?
Yeah, and I think she can address that with the county court of law number 1 when she goes there, but just tell her not to go back to, well, this was a theft case, right? At the HEB, alleged theft. Tell her not to go back to the HEB at 1211 East Frontage Road in Alamo, okay?
Yes, Your Honor.
Because they will call the police on her again if she shows up there.
Thank you, Your Honor. If I may have an opportunity to sit with my client and explain.
Yeah, if you can just sit in the back of the room.
Thank you.
Thank you. Next case we're gonna call is C 3871-23-I, State of Texas versus Manuel Zavala. Mr. Zavala is present in the courtroom. And you do speak English, correct, sir? Who's here for?
Andres Ramos, present for Mr. Zavala, Your Honor.
Okay, there you are. Mr. Ramos, the reason we are here, and Mr. Zavala, is because I received reports from probation that are concerning Mr. Zavala is out on a couple of charges of, I believe they're intoxication assault, 2 counts. I've received reports from probation regarding violations, alleged violations of the alcohol monitoring device, violations of the, appear to be the ignition interlock device. And that's why we are here. When I magistrated this individual back in September, I ordered that he have an alcohol monitoring, a portable device, an ignition interlock device. There were some windows that were put in there that he's supposed to be blowing throughout the day. No bars, no cantinas, no drugs, no alcohol. And it appears, based on the information that was provided to the court, and I had my staff send that information to Mr. Flores' office. So you should have a copy. Do you not, Mr. Ramos? Okay. Veronica, I sent it to, we sent it to Annalise, so I don't know if she forwarded it to you or not.
Not yet, Judge.
Okay. But that's my concern. There's some.
Understood, Your Honor. We discussed this matter. We discussed this matter with Mr. Zavala. We discussed with him the importance of the matter and the reason the court imposes conditions like these to ensure the safety of the community. I know that Your Honor is concerned. I guess first and foremost, we'll address them one individually. I guess the first and the most serious one is the one in which there was, I guess, there was a low percentage of a couple of blows on July the 9th, I believe. That particular judge, Mr. Zavala stated to us that there's been an issue with that particular mechanism that has given him problems before, and I advised him, well, you know, that is not going to look good in presenting that. You know, I also addressed the other issues of the photographs that the court has provided. You know, he knows there's cameras. I mean, he knows that the pictures of these matters, Your Honor. He was not. There's been no attempt to fool anybody. You know, this is not the. We've already discussed these issues. He already knows what the process is, Judge. You know, our concern obviously is the same as the court's concern. How do we address it so we can properly assure the state and the court that he's going to be safe, the community is going to be safe, and how we assure his presence in court, Judge? And one suggestion that in discussing, I spoke to another assistant district attorney, not Ms. Bernal, I wasn't aware she was going to handle it, but I spoke with Ms. Torrey from the district attorney's office, and we discussed, you know, a scram device that would kind of eliminate any other, I guess, potential issue with, you know, oh, I have hand sanitizer or those matters, or there's a false. And it's obviously a serious matter, and we want to address it. That is our position on that, Judge. I'm not sure how the state stands on this.
Well, my concern is not only the pictures where it appears that the camera has been moved around, because at some point it's facing him, and then at other points the camera is facing his lap. So there's an issue of who's blowing in that device, whether it's Mr. Zavala or he's having somebody else blowing the device. We also forwarded it to your office, several videos that were sent to us by the monitoring company where you see a female blowing in the device on the portable one, as well as his vehicle. He's also, you know, he was given a curfew way back when I magistrated him, 8 p.m. to 6 a.m. And there's, on this most recent one that I sent you, where he's out at 10 o'clock at midnight in his vehicle when he should be at home.
Yes, sir.
So he clearly doesn't understand the importance or the seriousness of what he's facing. I remind him that night where this alleged incident took place, 2 individuals ended up in the hospital while he allegedly ran away and left them there. Police have to chase him down at least a half a mile away from the alleged incident. And yet Here he is, what appears to be continuing to drink and get behind the wheel, driving a vehicle and putting not only his life, but other people's lives in danger. One solution in my mind was put him in custody, and we won't have to worry about him out on the road injuring other individuals, because he's got 2 devices and he seems to think he's figured out a way how to beat those devices and try and fool this court. That's not going to happen, sir.
Understood, Your Honor. We've discussed that matter with him, and we discussed that on what it looks like on its face. And we recognize that, Judge. Again, we assert to the court that this guy knows that these are cameras. He knows there are cameras on there, Judge. He wasn't trying to fool anybody. And also, Your Honor, I don't think there's as far as her driving, some other people can drive her vehicle, Your Honor, his vehicle. And so her driving the vehicle in and of itself, again, it didn't happen in a vacuum, and we recognize that. But her driving the vehicle in and of itself and blowing in that is not the violation. Obviously, it would be a violation. There was manipulation. We asked the court to consider all the factors, to consider his appearance, his voluntary appearances, and his continue to comply with any of the conditions the court may impose. They may be more stringent. We recognize that and understand that. That we'll need to do something to the court to assure the court that the community is safe, Judge. We'd ask any consideration, anything less than custody, we would comply with AIP, Your Honor.
Mr. Carvajal, Eric Carvajal is here for probation. I believe it was July 26th where there was an alleged violation. And when was he asked to come in to test, Mr. Carvajal? Do you know? Do you have that date?
Yes, Your Honor. On the day of the violation, I did call Mr. Zavala to report to probation.
What day was that?
That was going to be Friday, Your Honor. Last Friday.
Did he report?
Yes, Your Honor. He did. He did do a UA. He did come out positive for alcohol. He was given 3 days to go to fastest lab. However, we received the UA result, which is negative for alcohol, but we did receive it on Monday.
So he did submit something?
It was in 3 days. We do count Friday 1 day. So he should have gone by Sunday. We should have had the report by Sunday.
When did he actually test?
Monday, Your Honor.
So again, trying to fool the system here. Mr. Zavala, you're under oath, correct? Did you go in and test on Friday? Tested positive for alcohol, correct?
Yes, Your Honor.
And the test that they provide there is what the record relies on, not you going to take your own test. We rely on the test they provide there. They gave you an opportunity, and even then you didn't comply. You waited, they gave you 3 days, you waited 4 days.
If I may, Judge,
No, I don't think your attorney wants you speaking right now. I think he suggests you be quiet.
Correct, Your Honor.
I know that the court modified his bond conditions and allowed him to travel in the month of July to go take care of some continuing education and for work purposes.
Correct.
You're not proving that you're complying, Mr. Zavala. Go ahead and have a seat, sir. Take him into custody for right now. Mr. Ramos?
Sure.
Want to just stay on the screen? We'll recall it at the end of the docket.
Thank you.
Gonna call C 573-24-C, State of Texas versus Gloria Garcia. ¿Hablas inglés, verdad, Glenn? Se pone- Good afternoon, Carlos. She is Spanish speaking. Just ask that you go slowly so that they can do the translation.
Good afternoon, Your Honor. I'm Carlos Quintana for Ms. Garcia.
Good afternoon. You may proceed.
Your Honor, Ms. Garcia has been in custody since February the 14th of this year, and there has not been an indictment in her case. She does have a misdemeanor pending in court number 2, and we have a hearing on her next week. And so, go ahead and translate.
You got it. You can continue. He's going.
Okay. And we're asking at this time that the court grant she does have a bond of $30,000 that was set on the burglary or habitation with the intent to commit another felony, which we don't know what that is because we don't have discovery due to the fact that she has not been indicted. So we're asking at this time that the court grant a PR bond of $5,000. Again, she's been in custody since February the 14th of this year.
What says the state?
Your Honor, just to address a few things, I believe she goes by another name, Gloria Estefany Galicia Nandin. So the TRN had to be corrected. She has been in custody for over 90 days. At this point, Judge, the state would defer to the court. We would just add some conditions to make sure that she has no contact with Taide Hernandez, which is the alleged victim in this case.
Okay. What is your correct name?
¿Cuál es su nombre correcto?
Itzel Taide Martínez.
Decirlo mejor, por favor.
Itzel Taide Martínez.
Aida Martinez?
Sí.
Who is Gloria Garcia?
Me.
So you go by a different name? When I asked you, where do you live?
Infinitas.
Benítez.
How long have you lived there?
Vivimos ahí hace un año y luego nos mudamos a la 27 de este año y luego nos volvimos a regresar para la misma dirección donde me arrestaron.
About a year ago, and then they changed direction and then went back.
Do you have a job?
No,
Are you married?
no,
You have children? How old are you?
vale.
20 years old? Where were you born? Did you go to school over here? How long have you been in Hidalgo County?
Desde tengo 7 años.
When she was 7,
Who do you live with in Pinitos?
Con mi mamá.
mom,
We'll go ahead and issue her a $5,000 PR bond on this case. If you get out, actually, you still have another case in court too, that's your attorney needs to address.
algo menor.
You'll get a PR bond on this one. When you get out, stay in contact with your attorney because you're gonna have to show up to the courthouse at a later date to take care of both of these cases. You understand?
Aunque salga de aquí. Yes.
Actually, no contact with the alleged victim, a Taida Hernandez. You know who Taida Hernandez is? No one? Yes or no? Don't go over to her house. Don't call her. Don't text her. Don't send her any messages. You understand? Don't be even driving by the front of her house. Is that clear? Anything else, Mr. Quintana?
Nothing further, Your Honor. Thank you very much. Appreciate the court's time.
All right, good luck to you. For the record, I show that she's been in custody 175 days. Thank you, Mr. Quintana. Next case we're gonna call is C 3556-24-A, State of Texas versus Juan Gracia. Juan,
Good afternoon,
gracias.
Judge.
Habla inglés, ¿verdad? Okay, póngase aquí enfrente aquí. He's Spanish speaking, Ruben, just go slow so we can do the translation.
Yes, Judge, of course. Mr. Gracia, Judge, he has a $7,500 bond. He's been in custody of Williston County since, I believe, the 26th of last month, but he's been in custody since the 19th of last month with Hidalgo County. And we're just asking for a PR bond, Judge. He does have a job, construction. He lives in Alton.
He's got an ice hold, Ruben. I'm not sure if you knew that or not.
No, I didn't. Didn't get a chance to talk to him because he was in Williston.
Okay. What says the state?
Your Honor, our position is no reduction, given the fact that this individual has an ICE hold.
Mr. Gracia, how old are you, sir?
36.
What city do you live in?
¿Qué ciudad es? Mission.
Where?
Mission.
How long have you lived in Mission?
Tiempo llevo aquí. Allá voy para como para 15 años. 15 years living in Mission.
Are you married?
Divorciado. Divorced.
You have children? Do they live with you? Where do you work?
Building. Construction.
How long have you been working in construction?
Ya voy para 2 años. 2 years.
You understand that there's an immigration hold on your case. Do you know that?
Yes.
Which one? Which means that if you are released on bond, you will be released to immigration. And they may or may not deport you. Do you understand that? But your case is still going to be pending here, and you will have to show up at the courthouse at a later time to take care of it. Do you understand that?
Se tiene que necesita, a pesar de que no vive aquí, necesita ir a corte aún así.
You need to stay in contact with your attorney. Is that clear? Bond will be reduced to $1,500 cash surety. Anything else, Mr. Lula?
That's all I have, Judge. May I be excused?
Yes, sir. Thank you.
Thank you, Judge.
Gonna call C 3591. I think this was Spanish speaking. 3591-24-A, State of Texas versus Jorge Villarreal.
Good afternoon, Your Honor. Lidia Elizondo for the defendant. My client is in custody. He is a Spanish speaker.
Okay, hang on. Habla inglés, señor? Okay. He does have an ice hold also, but you may proceed. Just go slowly, please.
Yes, we're aware of the ICE hold, but he's been in custody in excess of the 90 days. He's actually been in custody over 120 days. At this point, the state has failed to move forward with an indictment against my client. So we ask that he be released on his on a personal cognizance bond. If that means that he gets deported, then he just gets deported.
What says the state?
Your Honor, the state would be opposed to any type of bond reduction given the ICE hold and the fact that he hasn't proven any assurances to the court that he'd be coming in for his arraignment, Judge.
Your Honor, my client is entitled to a personal cognizance bond under the Texas Code of Criminal Procedure. He's been in custody more than 90 days. The state had been made aware prior to today's hearing, actually about a month or two ago. This matter was before Judge Rose Reyna, and the state and the department at the district attorney's office that handles writs knew that they were getting close to the 90 days. They still didn't do anything about it. If this case was that important to the state to prosecute, they would have indicted my client prior to the 90 days. They have not done so. My client deserves a personal recognizance bond. He should be released. And if that means he's released to the federal government, then so be it. We would be vehemently requesting that personal recognizance bond for my client so that he can be released.
Mr. Villarreal, how old are you, sir?
20.
What city do you live in?
Reynosa.
Do you have any family here in Hidalgo?
Yes.
Who lives here? What family members here live here?
His wife?
What city does she live in?
McAllen?
She live in a house or an apartment?
House.
You have children?
One child?
Bond will be reduced, what's it currently set at, 60,000, bond will be reduced to $1,500 cash surety.
Your Honor, I would like to request the court reconsider since my client has been in custody over 120 days and is entitled to a personal recognizance bond.
Bond will be $1,500 cash surety. Mr. Villarreal, you understand that there's an immigration hold on your case? You understand that? Which, yes, which means that if you're released on bond, you'll be released to immigration. You understand that? And they may or may not deport you. I don't have any control over it. That's up to immigration. You understand that? But your case will stay pending here, and you'll have to show up at the courthouse at a later time with your attorney to address this matter. If you do not show up, they will issue a warrant for your arrest. Do you understand that? You need to answer. You can't shake your head.
Yes.
All right. Okay. That'll be the judgment of the court.
That's all I have. May I be excused?
Yes, thank you, Ms. Mount. I'm gonna recall C 3871-23-I, State of Texas versus Manuel Zavala. Go ahead and stand up, Mr. Zavala. Mr. Zavala, you heard Mr. Carvajal testify earlier that you were called in on the 26th to go get drug tested, correct? And you were drug tested and alcohol tested, correct? And you came out positive, correct? Have you been drinking? So yes or no question, sir. Had you been drinking?
Yes.
I appreciate your honesty, sir. You understand the seriousness of these charges, sir. 2 people ended up in the hospital with broken ribs and severe injuries because somebody chose to drink and drive. Every day, people are getting killed because of that. I put those conditions on you because I didn't want that to happen again. Not because I thought, oh, this guy can figure out a way how to beat the system and continue doing it. If I had known you were going to do that, I would have left you in jail. But I gave you the benefit of the doubt. And yes, I imposed a lot of conditions for a reason. The judge granted you permission to go and leave out of town. I bet if he had known these violations were going on, he wouldn't have let you go. I wouldn't have let you go. If you're going to come in here and lie to me, to these probation officers, officers of the court, I'll just leave you in jail. That's why I know that nobody's going to get hurt. You have that ignition interlock device in your vehicle? You still have the portable device? I said no drugs, no alcohol. That's no drugs, no alcohol, sir. Not a wine, cup of wine here and there, nothing. Is that clear? And the curfew, if it wasn't made clear at the beginning, because I was told by probation, you didn't know there was a curfew. There's a curfew, sir, 8 p.m. to 6 a.m. So you need to be at home by 8 p.m. You asked for permission to travel to go to a training in July in Austin. That's done with. What is the status of your mom? She's what?
It was my aunt that passed away.
Okay,
My mom's sister.
okay. There's no reason for you to go back to Chicago?
No, I do have a training in Arizona. I brought proof of the training from Austin here, just in case the court wanted to see it. But that the Arizona training is not for 6 months, right? So.
Well, let's see how you do over the next 60 days. And until this case gets indicted, if you're not going to comply, I guarantee I'll sit you back in jail. I won't hesitate. You understand me? No more travel out of state. That condition that was previously granted will be revoked. No more travel out of state. Curfew, 8 p.m. to 6 a.m. The alcohol monitoring device, 3 times a day, 6 a.m. to 8 p.m., 4 to 6 p.m. in the afternoon, and 10 p.m. to 12 midnight, every single day. And no more messing with the mouthwash or anything where you have all those violations. I did go over your test results with Mr. Martinez, who's also on the screen here from Safety Check. And he assured me that some of those violations appeared to be non-alcohol related. Now, I don't know if you were attempting to cover up what you were doing, but I hope that's not the case. Mr. Martinez, if you can provide to probation monthly reports on the alcohol monitoring device, and Mr. Carvajal, if you can follow up with a Lifesaver, which monitors the ignition interlock device, to make sure that we get a monthly report on those, and check for violations or where he's past the curfew and in his vehicle.
Yes, Judge.
May I ask the court a question? May I ask you a question? Is my wife allowed to drive the vehicle after hours?
Wife can drive the vehicle, but that doesn't mean you can be in there after hours. You have a curfew. You need to be at home.
I just want to make sure that it's okay for the vehicle to be used after hours.
She can use the vehicle, but if it's after the hours, you better not be in that vehicle. And you make sure that when you're blowing on that device, don't be messing with that camera, sir. Because to me, somebody's messing with it. 2 hours earlier, it's showing your face. 2 hours later, it's pointing at your lap. When somebody doesn't show up for a drug test, you know what we think? You know what that is to the court? That's a positive. They don't show up because they know they're doing something wrong. When somebody's messing with the cameras and stuff like that, it's because they're doing something wrong. You're blowing into that device, there's no reason why that camera shouldn't be on your face, not pointing at your lap. There's almost a whole month there where your head is out of the picture, pointing somewhere else. That shouldn't be happening. It's your last opportunity, sir. Anything else, Mr. Flores, Mr. Ramos?
Your Honor, thank you.
All right. He'll be allowed to, he'll be released. I need to hear back from probation end of the month, end of August, end of July, end of September, end of October. We'll continue monitoring him
Yes, Judge.
closer.
Yes,
No
sir.
out of town travel, sir. The curfew is 8 p.m. every day.
Thank you, Your Honor.
All right, thank you. That'll be all.
Thank you.